Hey everyone, Harry here to talk about a decision by the highest court in New York, which is called the New York Court of Appeals, to permit all registered voters to cast their ballots by mail. Okay, obviously that's an important decision that enfranchises millions of New York voters, but it wasn't a straightforward one. So the history of attempts to bring by-mail voting to New York go back a few years to the Cuomo administration and even before. The New York Constitution does not specify that a vote has to be undertaken in person, but there's apparently been a long tradition, whatever that means. The Court of Appeals talked about it, of people actually doing that and interpreting vote to mean that. And so the Court of Appeals actually, even though it's 6-1, describes the issue as a difficult issue from the start. The history is there's more to it, which is that there was an effort at first to make a constitutional amendment, making it clear that this could happen. That didn't succeed, and Governor Cuomo entered an executive order saying you can vote this way, and then a law was passed, signed by current New York Governor Kathy Hochul, saying that it's okay. So who could object to by-mail voting? And how did this come up? Well, yes, you guessed it. A Republican, and not just any Republican, the very flamboyant MAGA Trump advocate, Elise Stefanik, along with, she's the named plaintiff that sued the state, saying basically that the decision or the law violates the Constitution. And like all these Republican efforts, they really are on the side of disenfranchisement, but they try to cloak it in basic political language. Here's what Stefanik said: New York's court system is so corrupt and disgraceful that today's ruling has essentially declared that for over 150 years, New York's elected officials, voters, and judges misunderstood their own state's constitution. So what she's talking about is what had apparently been, though not supported in so many words, by the New York Constitution, a common understanding that when you vote, you come forward and vote. Now, of course, we're talking about, the 19th century and a time where it wouldn't have been feasible to have mail voting. But, now this is a provision that will really, in general, things that improve access for people who may not have time or money, working people in different states, are going to be in favor of Democrats and Democratic candidate and enfranchise more Democrat voters. So Stefanik is railing against it. It's basically a pro-voter provision that's a little hard for her to protest. Anyway, the court does go through a whole analysis why this is okay. As with many of these cases, COVID kind of figures in, and the need to have ways other than showing up to vote. Among other problems, of course, is huge disparities in different precincts, usually dovetailing with racial identity or socioeconomic class, where people have to wait so much longer. So in-mail voting being a very useful pro-democracy device. So there was one dissenting vote justice at the New York Court of Appeals who basically took the position, hey, this is the way it's been for 150 years, and so this is really a misinterpretation of the New York Constitution. And the majority of 6, as I said, did not make it seem like it. They started right out with saying it was a difficult case. Nevertheless, we should distinguish between the notion of a difficulty under law based on the idea that the Constitution has been interpreted in this manner for many moons, and difficulty of policy when you talk about in-mail voting. It's something that's pretty hard to object to. The record around the country is clear that in-mail voting is secure, reliable, and enfranchises so many people. But it's been a very big kind of clash point. Recall, even in the 2020 election, Trump was eager to have the voting stop because the counting of the in-person votes were more likely to be for him. And what happened in the actual voting was that what had seemed a little bit of a toss-up began to turn sharply against Trump once the in-mail votes were counted. A lot of states, you're not permitted to open and count them until the actual day. So in-mail voting is really an important feature that often tends to go for Democrats, and in this dramatic way, later in the day when decisions are actually made. So it's expected to be in New York, and now with this 6-1 decision, that's how it will be, and Elise Stefanik's effort to call it unconstitutional and corrupt fails. The 6-1 New York Court of Appeals upholds the law signed by the governor, and in-mail voting is now a established feature of the New York landscape in time for this year's presidential election. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.